The United States Supreme Court today put a halt to marriage equality in the state of Utah. 17 days ago, U.S. District Judge Robert Shelby ruled that that state's same-sex ban violated the Constitution of the United States, which was a pretty remarkable ruling. Then the 10th Circuit Court of Appeals refused to offer a temporary stay to that ruling 3 times, which meant that upon issuance of the decision, and for a 17-day period, plenty of scenes like this unfolded in Salt Lake City, allowing hundreds of Utah gay and lesbian couples to get marriage licenses. It also meant the U.S. Supreme Court had to weigh in, and today, the highest court in the land stepped in and said, no more. No more marriage licenses will be issued in the state until the U.S. Appellate Court system has a chance to actually evaluate the state of Utah's appeal of the decision by the district judge. So, where does that leave the 950 gay and lesbian couples who are possibly, maybe, sort of legally married in the state of Utah? To find out, joining me now, Matthew Breen, editor-in-chief for The Advocate, and Camilla Taylor, marriage project director for Lambda Legal. All right, Camilla, were you surprised by this Supreme Court decision?
Well, I was a bit disappointed, Chris. I mean, the papers by the couple opposing the stay were very strong, but it is actually quite commonly granted. In fact, in almost all of the cases in which we've won marriage in state high courts, a stay was granted pending the final determination by the state high court. In fact, there's only one exception to that.
I gotta say, actually, I was shocked that there was no stay offered at the lower levels, because it seemed to me that this was paving the way for creating a situation in which you possibly had a whole bunch of couples in a very strange kind of legal limbo.
Well, I think it was pretty shocking that the stay was not granted by the 10th Circuit Court of Appeals as well as the District Court, given the history of stays being granted in these circumstances. But there's something important to remember here, which is that the fact that the Supreme Court halted the further issuance of marriage licenses through this stay, that doesn't do anything about the validity of those 1,000 marriage licenses that are already out there. They remain perfectly valid.
That is a big choice. So there's 2 issues on the table right now, right, Matthew? There's this question of what about those couples, and there's a question about the law more broadly. I want to play Utah Attorney General Sean Reyes talking about what the stay means for those couples. Take a listen.
We don't know the answer yet as to the marriages that have taken place already. There's no precedence, I believe, for this. And this is precisely the uncertainty we were hoping to avoid by requesting a stay immediately upon the decision of the district court. It's unfortunate that many Utah citizens have been put into this legal limbo.
You can't take people's marriages away from them, right?
No, there is precedence for this, and you just referred to that. California, Prop 8.
Right.
People were granted the permission to marry due to a state Supreme Court decision in California in 2008. A lot of people got married.
Right.
When Prop 8 was voted into law, removing the right, it did not invalidate the marriages that already happened. I don't see, I'm not a legal expert, I don't see any reason that the people who are legally married should be unmarried summarily.
Absolutely.
Camilla, it seems to me like it would be an incredible assertion of state authority to reach into the lives of 1,000 married couples and tell them they are no longer married.
Mm-hmm.
Absolutely. I think it's very clear that those marriages are valid, and there are, of course, 17 other states in the country and the District of Columbia where same-sex couples currently can marry. So certainly this decision of the Supreme Court to put a stay on the further issuance of marriage licenses in Utah doesn't halt the momentum that the freedom to marry is already achieving.
Before this decision, Matthew, you're a native of the state of Utah, if I'm not mistaken. Before this decision, a month or 2 ago, when we were mapping out where the next battle lines in this fight were going to be, I don't think anyone had Utah on the radar.
No, I did know that there was a lawsuit in progress, but I did not expect a result. Nobody was expecting a result until January, in fact. So the idea that this was the next state, a lot of these judges are appointed by Republican governors and so forth. Nobody expected that Utah was next at all.
And one of the things that has happened is, of course, in reaction, there has been a backlash. This is a Utah police officer and Arizona Sheriff Richard Mack leading the Constitutional Sheriffs and Peace Officers Association uprising against gay marriage. Take a listen.
The people of Utah have rights too, not just the homosexuals. The homosexuals are shoving their agenda down our throats. Sheriffs need to defend the county clerks in saying, no, we're not going to issue marriage licenses to homosexuals.
There was also reporting that there was going to be a lot of fundraising for a fight in Utah. What do you think the contours of this politically will look like in Utah?
Well, you know, Utah's a very interesting place due to the
history they have with marriage.
The LDS Church has not said a whole lot yet, except that they support the decision by the Supreme Court to issue a stay. My hope is that they'll stay out of it just a bit, given the backlash, the Mormon Church, exactly. Given the backlash they got over Prop 8.
Right.
I doubt that's likely. They will find ways to wield influence. We're seeing that there's a call for $2 million to spend by the Attorney General to defend the ban on same-sex marriage, you know, and compare that to the $2.3 million, which was used to defend DOMA by the House of Representatives.
Right.
We're talking about a lot of money. We're talking about a substantial energy, you know, and we're talking about like sheriffs wanting to defend a county clerk's right to disobey the law.
Right. Camilla, very briefly, what next for this case in the Supreme Court?
Well, the 10th Circuit has actually put this case on a very expedited schedule. So the briefing will be concluded next month, and it's conceivable that the 10th Circuit could actually render a decision by this fall, leaving the Supreme Court an opportunity to take it then.
Wow, and then we get a square, straight-up ruling on the constitutionality of marriage bans. That'll be something. Matthew Breen from The Advocate, Camilla Taylor from Lambda Legal. Thank you much. That is all in for this evening.